Hello, everyone, and welcome. I'm Janelle Blakely, Chief Philanthropy Officer at the Seattle Public Library Foundation. Thank you so much for joining us today and for supporting two of our city's incredible institutions, the library and town hall. This webinar series has been a long-standing collaboration with our wonderful partners at the King County Library System Foundation, the Snow Isle Libraries Foundation, and others who share a commitment to strengthening libraries and learning in our region. And we're especially excited to partner with Town Hall for the very first time today. And thank you, Jill Robinson from Town Hall, who you'll meet in just a moment. But first, I am personally thrilled to be here with you because I'm brand new to the foundation. Today is actually my 7th day on the job, and I already feel incredibly welcome by this community. And I'm really looking forward to getting to know many of you in the months and years ahead. Before we move on, I'm going to turn it over to Jill for a brief introduction.
Hello, I hope I'm not echoing too much. Something just happened to my camera.
You
Um,
sound great, Jill.
oh, good. So glad. Um, I am the Director of Development with Town Hall Seattle, and I'm so pleased you could join us today. Thank you for taking that time. As I do my own planning and work with aged parents, and I'm just thrilled to be partnering with the librarian, Teresa, to present this webinar today and to be available to work with people in the future. So thank you so much for supporting our organizations and joining us today.
Thanks so much, Jill. Thank you again and Town Hall for being here. So each time we host one of these webinars, we're really reminded how transformational legacy giving can be. These gifts help ensure that organizations like ours remain vibrant, accessible, and responsive to our communities for generations to come. Anyone who chooses to include an estate gift is invited to become part of the Foundation's Library Legacy Society. This is a special group of supporters who share a lasting commitment to the future of our library. And if you've already included the library in your plans, thank you. And if you're simply curious about estate gifts, endowments, or other ways to create a meaningful legacy, we would really love to connect with you. And at the end of today's presentation, our contact information will be on the screen. So a few quick things before the presentation begins. First, we are recording this session, and you will receive a link to the recording and slides after we wrap up, so don't feel like you have to write everything down. Our fantastic speaker, Teresa Byers, thank you so much for Teresa for being here. She will be answering your questions throughout this presentation and at the end of the presentation. So if you think of a question you'd like to ask, please be sure to use the Q&A box that's at the bottom of your screen, not the chat, to make sure that we all see it. And if you see a question that you'd especially like answered in the Q&A box or that you've been wondering yourself, use the little thumbs up button next to the question to upvote it. So Teresa will be sorting the questions by your upvotes. So the ones with the most votes are what she'll be seeing first. And we'll get through as many of your questions as we can. Finally, when you sign off today, you will be invited to take a very short survey about your experience. And please take a few minutes to complete this if you can. We really value your feedback and it helps us shape future webinars. And to sweeten the deal, everyone who completes the survey will be entered in a drawing to win raffle prizes like a bag of books. So you don't want to miss out on that. I'm now so excited to invite our speaker, Teresa Byers, to join us on screen. Teresa is an attorney at Ogden Murphy Wallace, PLLC. She specializes in estate planning, probate, and estate litigation. And we are just thrilled to have Teresa with us today to share a wealth of knowledge on the process of leaving a legacy. So, with that, Teresa, please take it away.
Now I'm off mute. All right. Thank you so much. I'm excited to get a chance to meet with all of you today. Um, I know that this process can seem at times a bit overwhelming, non-intuitive. And so really the goal of today is just to familiarize folks with some common estate planning concepts. Um, I'm not going to be giving individual legal advice to people, nor am I going to recommend that after this you all go and get on ChatGPT or some other AI forum and AI draft your wills. That would be a terrible idea for you, but a great idea maybe for the litigation part of my practice going forward. So really today is a chance to go through what an estate plan is and perhaps identify some areas of misconception or some follow-up that it would make sense for you to do with your own counsel or with a financial advisor. So I'm going to start by sharing my screen. And hopefully this means that all of you can now see a slide that says estate planning basics. What am I doing again? I'm assuming that you are all sitting here today, spending your time because you have an idea that you might need an estate plan or you might need to update your estate plan. So let's start at the very beginning with the basic concept of what is an estate plan. So to me, and for the purposes of our discussion today, an estate plan is a process by which your assets will be managed and distributed upon your incapacity and death. So, when we talk about estate planning, a lot of people have a really narrowly defined concept of my estate plan is my will. And I'm going to offer to you an alternate theory, which is that you care more about what happens and who is managing your assets while you're alive than you ultimately will once you're dead. So, when we talk about estate planning, some really important concepts to start with are who's going to manage those assets in the event of my incapacity. So, we would be looking at a power of attorney, which is a document that is only effective during your lifetime, but is designed to allow someone to manage their finances and healthcare if you are incapacitated. We'll talk a little bit about revocable living trusts. So these are trust documents that are amendable or revocable by you, and they are effective both during your lifetime and upon your death. We'll talk about wills, which are only effective upon your death. And we'll talk about beneficiary designations for non-probate assets, which are similarly only effective upon someone's passing. Let's also talk about what happens if you don't have any of these documents. So, the good news is if you don't intentionally create an estate plan, the state of Washington creates one for you. And it does it in perhaps a less than optimal way. But we do have a process by which if you become incapacitated, someone can go to court and petition for what's called a guardianship. So the ability to make decisions about your person. So where you're going to receive healthcare, what type of healthcare you're going to receive, if you're going to be admitted to an assisted living facility. We also have the ability to petition for conservatorship, which is someone to manage your finances. So distinct from your body, the conservator is someone who has access to your bank accounts, your retirement assets, the authority to perhaps to sell your house to allow you to pay for care or because you're no longer going to be living there because you've moved to an assisted living facility. A few things to know about both conservatorships and guardianships. These are not short processes. When someone petitions for guardianship or conservatorship, the court appoints a court visitor, and that person actually does interviews, has information from your doctor, and reports back to the court after 60 days. So in order to get a conservatorship or guardianship set up, can take quite a while. and it's a relatively invasive process. The guardian and conservator is also required to report to the court every year with an annual report. So you have ongoing court supervision and monitoring, which on one hand might be great, but does mean it's kind of an expensive process because you continue to have attorneys and financial advisors and things like that who are actively involved in this court supervised process throughout. If you pass away without an estate plan, then the state of Washington has what's called the intestacy statute. And the intestacy statute is essentially a default will. And so it states, if you pass away without a will, we presume that you intended to benefit the following people. The obvious ones perhaps might be your spouse or your children. Less obvious, if you pass away without a spouse and children, your parents, then your siblings, and your siblings' descendants, and so forth downward. So there is a provision for what happens if you pass without a will to your probate assets. Non-probate assets will pass pursuant to the contractual defaults in your existing documents. So if you have a 401k account or an IRA with a financial custodian, you would have signed a contract with that financial custodian. And that contract will state who will receive those assets upon your death if you have not separately executed a beneficiary designation form. Certain non-probate assets, specifically retirement accounts like 401k accounts, may have a federal overlay of law that requires, for instance, that a spouse be named as the beneficiary unless there is a spousal consent. So every person here, whether they think they have an estate plan or not, actually does. And again, it's a function of Washington statutes, the contracts that you signed for your various assets, and federal law. So it's this kind of interwoven web. Let's take a moment and talk about what a power of attorney is. So this is a legal document. It needs to be properly witnessed by two disinterested witnesses, and if it has provisions related to real property, it also needs to be notarized. So this is a legal document in which you appoint and name an individual or a professional fiduciary, an entity, to make decisions for you in the event of incapacity or unavailability. So incapacity might be that you've had some sort of accident and you're under anesthesia. It might be long-term disability, so you have dementia or Alzheimer's or something that affects your ability to make decisions for yourself. Or it may be unavailability. So perhaps you're out of the country and you're unavailable to execute documents related to your required minimum distributions before the end of the year. Or your spouse is traveling for work and you're in the process of doing a major asset acquisition, buying a new house or something like that. The agent under a power of attorney can act for the principal to execute those documents on their behalf. So powers of attorney can give very, very broad grants of authority. So it includes things usually like the ability to file income taxes, to engage in litigation on behalf of the principal, perhaps to engage in an audit with the IRS, to provide instructions to financial institutions, so make deposits or withdrawals from bank accounts, provide instructions for required minimum distributions and where those will be deposited to, buy and sell assets from very, very small assets to very, very large assets, and in some cases, the ability to make gifts. This is usually pursuant to a larger gifting plan if that's part of your overall estate planning. You can have in the same document or in a separate document a power of attorney for healthcare matters. So this is an individual who has the authority to admit you into a medical facility, determine what types of treatment options you will have, and you may give them the authority to make end-of-life decisions for you. This would be the ability to take you off a heart and lung machine or off artificial food and hydration in the event you were in a persistent vegetative state or an irreversible coma. I always tell people when you're thinking about who your agents are going to be for a power of attorney, don't cross the streams. So if you have someone in your life that you think is absolutely fantastic at financial matters, they balance their checkbook down to the penny every month, and they love thinking about stock markets and annuities and all of those types of things, but they pass out at the sight of a doctor, please make that person your financial agent under a power of attorney, but not your healthcare agent. Similarly, if you have someone in your family who is a doctor or a nurse or is a social worker or really excellent at communicating with medical providers, but they can't balance their own checkbook, please, please think about making them your healthcare agent, but not your financial agent. Keeping in mind that anytime you're asking someone to act in these fiduciary roles for you, it's going to be a very stressful time for them. And it's somewhat non-intuitive, but the people sometimes that we most rely upon are going to be the people who are not going to be best situated in a moment of incapacity or loss to be making some of these decisions. So please be very thoughtful about who you have as your agents in these roles. Sometimes people will ask me, can I have co-agents? And certainly you can. I will caution, however, that if there is a power imbalance between the two people that you're thinking of appointing, or they don't get along currently, they will get along less after some sort of major event that causes them to have to act as an agent under a power of attorney. So if people don't get along on the front end, please don't ask them to get along in a stressful situation and make decisions for you in that situation. It won't go well for anyone. Sometimes people will also ask me, with a healthcare power of attorney, is this someone who can involuntarily commit me? And the answer to that is no. So we do not grant the ability to involuntarily commit someone to an individual. Only the state can involuntarily commit someone who's a danger to themselves or others. So even a healthcare agent under a healthcare power of attorney will not have the ability to make someone stay in a hospital over their objections. All right, what can a will do? The first thing to keep in mind is a will is only effective upon your death. It has no validity and no role to play and no judicial review until you've passed away. It is a privileged document, so it's not something that you need to share with anyone. You're welcome to, but it's not something that you need to. So what does a will do? Well, one thing that a will does is it establishes who is going to be your executor. So who is the individual or entity that you charge with stepping into your shoes because you've passed? And one of the ways to think about this is a will is admitted to probate. Probate is the process of changing title. So when you pass away, someone has to step in and finish off all the things that you didn't finish off before you passed away. So they're going to go through your files, whether those are your paper files or in the modern world, your digital files. They're going to try and find your assets. So where did you bank? Where did you have your retirement assets? Did you have an annuity? Did you purchase life insurance? Do you have some sort of deferred benefit plan through your employer or a pension? So a big part of what the executor does is just finding all of your assets. In the process of going through that review, they're also going to be identifying your creditors. People like to tell me, oh, I don't have any creditors. I pay everything off every month. And that's great. And that's wonderful if you can do that. However, very, very few of us pay off our last creditor and then die a moment later. Most of us have some creditors that we haven't paid at the time we've died. In addition, if you were at any point hospitalized or receiving medical care, you may be aware that sometimes it takes a long time for those medical bills to get through insurance and come to you. So an important part of what an executor is charged with is finding those creditors, noticing those creditors, and then reviewing any claims made by those creditors to ensure that they should actually be paid and that there's not some other source of payment or not a fraudulent claim. Your executor is also charged with paying your taxes. So this is your income taxes, your final income tax filing, any state and local taxes that you owe, and then state and federal estate taxes to the extent that you have an estate that is subject to estate tax. And then ultimately, once the executor has identified all of your assets, identified all of your creditors, paid your taxes, paid any appropriate creditors, they then are charged with distributing the remaining assets in accordance with the beneficial provisions in your will. Your will can also nominate a guardian for your minor children. And I'm going to distinguish between establishing an executor. So you nominate an executor and the court confirms that appointment. But the court is very differential to your nomination. You also nominate a guardian for minor children. But minor children, if the guardian is someone other than their parent, will have to go through a separate guardianship process. And that nomination is, in fact, just that. It's a nomination. It's a suggestion to the court of who should be the guardian for minor children. So a will not actually appoint a guardian for minor children in and of itself. The will pass assets that are titled in your individual name without a beneficiary designation to whoever you designate as the beneficiary. So some of the best examples of this are perhaps your house. So on the deed to your house, that will list your individual name usually. So that's an asset that would pass through probate and in accordance with the provisions of your will. If you have investment accounts that do not have beneficiary designations, transfer on death, or pay on death designations, those investment accounts will pass under your will. And then if you have business interests, so LLC interests, C Corp shares, partnership interests, those assets will also generally pass under your will unless there's a mandatory buyout provision or something like that in the operating agreement of that business entity. Your will can also create future trusts, what are called testamentary trusts, trusts that spring into existence because of your death. And these might be trusts for a spouse, they might be trusts for children, they might be trusts for a family member who is in some way in need of supplemental care. And then your will can also provide for how you want your taxes and expenses of administration allocated. And this can be a very important provision for reasons we're going to talk about in more detail later, but that is your will not control the transfer of all of your assets, but it can provide for taxes to be paid either pro rata from your assets or entirely from your assets passing under your will. And so an important thing to be keeping in mind if you have significant non-probate assets is where the money to pay taxes on those non-probate assets will come from. All right, so let's talk about revocable living trusts. So what is a revocable living trust? First and foremost, it's essentially an alias. It is an amendable, changeable trust document, and it's really designed as a probate avoidance tool. It is not designed as a tax avoidance tool. It is not designed as a creditor avoidance tool. So the state of Washington does not recognize what's called a self-settled trust or a trust you create for your own benefit for creditor protection purposes. Revocable trusts are also not recognized as a separate legal entity for income tax purposes during the lifetime of the grantor. So, what is it that this is designed to do? Some states have very complex and or expensive probate systems. So, if you have property or family members in California, Florida, or Hawaii, places where there are complex probate systems that can be expensive, they will tell you that you absolutely need a revocable living trust as part of your estate plan. In Washington state, that may not be true. Washington has an abbreviated probate process. We have what are called non-intervention probates. And what that means is that there's a statute that provides if you have a non-intervention probate, your probate process is treated the same as though you had a revocable trust. So once the probate is opened, your executor has all of the same power and authority that a trustee of a revocable trust would have. And the court does not supervise those probates once they're opened. So there's an initial pleading to open the probate, and then there's very little else that happens in the court supervised probate. So, knowing that Washington has this abbreviated non-intervention probate system, why would someone have a revocable trust in Washington state? Well, the first reason is they might own out-of-state real property, dirt. So, a house, a condo, a timeshare, vacant property in another state. And because real property is subject to the jurisdiction of the state in which it's located, if you own real property in your personal name at the time of your death outside of Washington, but you are otherwise a Washington resident, you will have two probates when you pass. You will have a probate in Washington, and you will have what's called an ancillary probate in that state in which you own alternative property. So if you have a vacation home in California, you'll have your primary probate in Washington, and you will have an ancillary probate in California. Revocable living trusts are used to avoid that. Instead of titling the dirt, the real property, in your individual name, that dirt or real property is titled in the name of the revocable trust during your lifetime, so that when you die, there is no property held in your name that needs to go through probate in that state. So, one reason that people have revocable living trusts in Washington state is because they have out-of-state real property. Another reason is they might have some privacy concerns. So wills are filed with the court, they become a matter of public record, which means that anyone can go look those up. Now, as a general rule, we don't put a lot of personal information into wills. We don't include social security numbers. We don't include bank account numbers. In fact, we generally don't include values. However, if you have estranged family members, if someone is famous, if someone thinks that there is someone who's going to go and nose around in their business, they might choose to have a revocable trust as their primary estate planning tool. And then the last question I ask people who are considering whether or not a revocable living trust is right for them is, what is the likelihood that you might be moving to another state? If you know that you will be leaving the state of Washington and moving to a state in which there is a more invasive probate process or a more expensive probate process, you might choose to have a revocable living trust established now, fund that trust now, and then you'll be better prepared to move to a state that has a more onerous probate process. One thing that's really important to remember about revocable living trusts is they only work to avoid probate if you place assets into the revocable trust during your lifetime. If you continue to hold assets in your individual name at the time of your death, even if you have a revocable living trust, we will have to go through probate to transfer the assets from your individual name into the revocable living trust. And that's why it's very, very, very important that even if you have a revocable trust as your primary estate planning vehicle, you still need to have a will. It's there to catch anything that doesn't get placed in the trust during your lifetime. Sometimes they're referred to as pour-over wills. They're very abbreviated wills, and their purpose really is to say, if I forgot to put something into the revocable trust during my lifetime, please use the probate process to put it there once I've passed away, and then distribute that asset in accordance with the terms of the revocable trust. I'm just going to pause here really quick because I want to see if, it does look like we have a couple of questions related specifically to revocable living trusts. And the question here was, do the assets in a living revocable trust count towards your total assets at death for the purposes of determining if estate taxes will be levied? And the answer is yes, absolutely. Assets in a revocable living trust are included in your gross estate for both state and federal estate tax purposes. There are a lot of misnomers about what is included in gross estates. A revocable trust that is funded by you with your assets is included in your estate for estate tax purposes. Non-probate assets, so life insurance, retirement accounts, are also included in your estate for estate tax purposes. We do not tax only probate assets. We tax all assets owned by the decedent at the time of their death for estate tax purposes. There was also, going back, a question about financial powers or powers of attorney, whether you need separate powers of attorney for financial and medical purposes. You can have your financial and healthcare power of attorney done as a single document or done as separate documents. It's really a matter of preference. The powers given to each of the agents are different, but the document can be combined or can be separated. It just depends, and it's up to you. Okay, non-probate assets. I've alluded to these a couple of times, and this is a really important piece of information for people to understand. Your will does not control the distribution of your non-probate assets. And in fact, your revocable trust is unlikely to include the distribution of your non-probate assets. And what do I mean by non-probate assets? Non-probate assets are assets that pass by beneficiary designation or as a matter of contract. So as I alluded to earlier, your retirement accounts, your 401k, your IRA, your Roth IRA, any sort of death benefit on your pension, those retirement accounts all allow you to designate a beneficiary. If you don't designate a beneficiary, they're going to pass in accordance with whatever the contract with the financial institution you have provides. Life insurance also has a beneficiary designation. It's also included in your estate for estate tax purposes, unless it's held in an alternate vehicle called an irrevocable life insurance trust. But life insurance, you need to make sure you have a designated beneficiary. Again, if you don't do one, the contract will provide a default for you, but in either event, it's unlikely to pass under your will or revocable living trust. Joint bank and investment accounts. So these are accounts that you see held as joint tenancy with right of survivorship, sometimes called JTWROS. When I look at what causes litigation and difficulty for my probate clients, this is one of the single largest areas of concern, particularly if you have an estate that's going to be subject to state or federal estate tax. It is critically important that your investment accounts are properly titled. If you are planning to do some sort of tax planning in your documents, so you have a spousal trust, for instance, or sometimes what's called a bypass trust, a marital trust, an AB trust, and your assets are largely in investment accounts that you hold as joint tenants with right of survivorship, those assets will not pass under your will into those tax planning trusts, because the joint tenancy with right of survivorship designation passes those assets directly to the surviving joint tenant outright. Sometimes people will also, as they get older, they'll say, oh, I'm going to add my child or my agent to my bank account as a joint tenant so they can access it and help me pay bills. If you do that, when you pass away, that account will pass to the now surviving joint tenant, your agent, your child. It will not pass under your will or revocable trust and be distributed out to all of the beneficiaries. So it's really critical and important to take the time to go back and look at all of your bank accounts and all of your investment accounts and make sure they're properly titled. And if you have questions about how they should be titled, please go speak with your attorney about it. Have them walk with you through how that account or how that asset is going to pass under your estate plan. Pay on death or transfer on death designations. So these are designations that you can add to a bank account or an investment account. You can actually add them on a deed for a house that again provide when you pass away, that asset will be transfer on death or pay on death directly to an individual or an entity, a charity, bypassing the planning under your will or revocable living trust. Again, this does not avoid estate taxes. It's purely a probate avoidance tool. Pensions similarly can have beneficiary designations if there's a death benefit on that pension, as can annuities and employee benefits, particularly for city, state, or federal employees. There's what's known as the PERS program, and each of those programs has an opportunity for beneficiary designations. All right, let's pause here. So the question is, if I have beneficiaries identified in my will and also in my financial accounts, and they are not the same, which takes precedent? So if you have added a pay on death or transfer on death designation to an account directly with your financial institution, generally speaking, that beneficiary designation will take precedent over the terms of your will. And that's because your will only applies to assets that pass through probate. And if you have added a pay on death or transfer on death designation to an individual account, naming a person or an entity, then that designation will generally control. There are some pieces of that that make it a little more complicated. If you have a surviving spouse and there was community property in the account, the surviving spouse may have a community property claim. And there are certain types of assets that can be subject to what's called a super will provision. However, for the vast majority of people, if you have added a pay on death or transfer on death designation or a joint tenancy with right of survivorship designation to an account, that designation is going to trump any intent otherwise stated in your will. What if joint owners of an account pass away together? So in the event of simultaneous death, if the account was community property, so if it was a husband and wife who had a joint tenancy with right of survivorship account and there was no pay on death or transfer on death designation, then the account is likely to go through probate. If it's community property, one half will go through each spouse's estate. So the spouse one's estate will have one half of that account, spouse two's estate will have another half of that account. If the joint tenancy with right of survivorship was not a married couple, then the account will be allocated in proportion to the contributions of the individuals to that account. And then their allocable portions will go through their respective probates. Okay, so assuming you have an estate plan, do you need to update it? Well, it depends a lot on what's happened in your life. So one, have you changed your friends or advisors or fiduciaries? Did you name someone as the guardian of your minor children that you were really close to when they were 5, but now they're 16, 17, and they would actually really prefer to stay and finish high school here and not move to Auntie Tina's in Florida? You might need to think about that. Changes with your children more generally. Did you last do your documents when your children were 5 and now they're 55? Are you concerned about who your child has married or is married to? Do you need to make some provisions around that? Or do you love the person they're married to and you want to make some provisions to benefit your son or daughter-in-law? Do your children have children such that you have grandchildren and you would really like to make some provisions for them or be thoughtful about how assets will be used for their benefit? Have you made different life choices or have your children made different life choices, such that perhaps assets that were going to be held in trust for them can now pass to them outright, or assets that you were planning to pass outright should really now be held in trust? Do you have new assets? Have you moved bank accounts around? Have you moved retirement assets around? Maybe you don't need to update your whole estate plan, but you need to meet with your planner and go through and make sure you've got your beneficiary designations done correctly. Have the value of your assets increased? If you have lived in Seattle for the last 20 years and you own a house, you know the value of your assets is increased. And that may mean that you have an estate tax issue now that you didn't anticipate having. Again, estate taxes apply to the gross estate regardless of the transfer mechanism used. So if your assets have increased in value, whether it's your retirement account, the value of your house, your business assets, might be time for a review. Have you moved to a new state or here from another state? Because probate is state specific, it really makes sense if you're moving between states to have someone take a look at your documents and decide if it would be a good idea to update your plan, however you've established that plan, so that you have documents that are specific to the state in which you currently live as your primary residence. Again, beneficiary designations, beneficiary designations, beneficiary designations. If no one told you how to fill those out in the first place, please go back and consult with someone about how to fill those out now. This is just an absolutely critical part of estate planning, and it has nothing to do with the will that you signed. Changes in charitable values or your ability to act on those values. Maybe the last time you were talking about estate planning, again, your kids were 5 and 10, and you didn't have the assets you have now. And maybe now it's time to think about doing some more lifetime gifts, or maybe it's time to think about doing a bequest in your estate plan. Maybe the reason that you purchased that life insurance, namely to pay off your house, is no longer as important, but you still have that life insurance. And maybe it's a great time to think about benefiting a charitable organization with that. Changes in estate taxes. So Washington State updated our state estate tax in July of 2025. We now have a $3 million exemption indexed for inflation. So $3,079,000 as of January 1st of this year. The current federal exemption is 15 million. But it's important to, if you haven't looked at your documents in a while, make sure that your documents account for the state estate tax system and the federal estate tax system. Those two systems were linked until 2001, and they are no longer linked. Washington has had a standalone estate tax since 2005. If you haven't taken a look at your documents since then, I can assure you your documents don't comply with current state and federal law. We also had the Secure Act. So this has implications for those income tax deferred retirement assets, your 401ks, your traditional IRAs. We have new payout rules. We also have, because of that, a need to update those what are called testamentary trusts, the trusts that spring into your existence upon your passing, whether it's a trust for a spouse or a trust for children. You may need to update your trust to have what are called conduit trust or look-through trust provisions in order to allow you the greatest, or your beneficiaries, the greatest flexibility in dealing with those income tax deferred assets. Talking a little bit about the benefits of charitable giving. The most obvious one is it feels good. So why would anyone create an estate plan benefiting a charity or do lifetime gifting? Well, hopefully because it makes them feel good about themselves and their place in the world and the work that that charitable organization is doing. It can be a great expression of values. So it may be a way to communicate to other beneficiaries, this is something that's important to me, and I hope it's important to you too. It can be a way of effectuating change. So keeping in mind that funds that are used for charitable giving generally receive an income tax deduction, making them income tax efficient. It also means you're perhaps funding less in taxes. So if you like what the federal government is doing at any given time, or the state government is doing at any given time, pay more in taxes. If you're looking to change that, find a charity that reflects what you would like to see changed. In addition to being income tax efficient during your lifetime, charitable giving is estate tax efficient because you also receive an estate tax deduction for distributions to qualifying charities through your estate plan. So I know we're about out of time, but just some baby steps in charitable giving. Remember to think about bunching lifetime gifts now that we have an increased standard deduction. Also think about qualified charitable deductions on IRAs. This year, 2026, you can give up to $111,000 using a qualified charitable deduction out of your IRA. Gifts of appreciated stock are great because if you gift the stock, you don't recognize the capital gain. And if the charity is a qualified charity, it won't recognize capital gain when it sells that stock. And then think about using your retirement assets, which again are these income tax deferred assets, if you intend to do testamentary gifts to charity, because unlike individual beneficiaries who will have to pay that deferred income tax on those retirement assets, the charities will not. So I'm going to stop sharing and oh, bigger question. So if I move out of the country, how are estate taxes affected? So as long as you are a US citizen, regardless of where you are, the United States taxes you on your worldwide income and your worldwide assets. So you will still be subject to federal estate taxes as long as you are a US citizen. If you are choosing to expatriate, that's going to effectively speed up and trigger perhaps some estate taxes if you choose to give up citizenship and leave the country. But that's really simply moving out of the country but retaining your citizenship is not going to significantly is not going to mean that you're not subject to US tax laws. All right. And I think I am supposed to wrap up right about here.
Yes, thank you so much, Teresa. Let's just give Teresa a big thank you for sharing her time, expertise, and thoughtful insights with us today. We really hope you found this session helpful and inspiring. And as I mentioned, we'll be sending a follow-up email with the recording and slides in the next couple of days. So please keep an eye out for that. As you exit the webinar, you will be invited to complete a short survey, and everyone who completes it will be entered into a prize drawing, which includes a grab bag of books. So we would really appreciate it if you could complete that short survey. And as you reflect on your own legacy planning, we hope you'll consider how a charitable bequest can support organizations that you care about, including those that promote literacy and create meaningful community experiences like the library and town hall. We are truly grateful for your support. And if you've already included us in your plans, we love to know so that we can thank you appropriately and help ensure your wishes are honored. And if you have any questions or would like to continue the conversation, please reach out. Our contact information will be on the screen shortly. And just thank you again for being here today. And we hope you have a wonderful rest of your afternoon. Thanks, everyone.